I think these amendments are critically important. They get to the heart of many civil liberties issues. They're being discussed in the context of our supposed desire to combat terrorism, and yet, as Deputy Wallace has said, terrorism is something which we facilitate on a daily basis by being complicit in the efforts of the US war machine, which has been the key reason why terrorism has exploded in the Middle East, has been destabilised in the manner in which it has been. Now, the reality is that the so-called threat of Islamic terrorism has been absolutely exploited by political establishments since 2001, and it's been used to curtail freedoms, to abuse human rights, to expand the scope of state security, to restrict freedom of movement, to militarise everyday life. And the consequence has been that the security and protection industries have become fat, selling their protection products. But the reality is that the world is a much more unsafer place than it was before. And I think this piece of legislation is unnecessary. It's a disproportionate response to an overhyped threat, whose potential to curtail freedom of expression is very worrying and unnecessary. Now, the group of amendments are done in such a way as if one wasn't accepted, another one would have been. Our preference is, and there's essentially two things going on in the group of amendments. One of them is to remove all references to public provocation, one set of amendments, and the second sort of main thread is to change the wording in the definition of public provocation in order to remove, as it is now, encouraging directly or indirectly the commission of a terrorist activity, and to replace that instead with directly inciting. Now, this isn't an abstract or an academic question as far as we're concerned. It's actually critically important. And the terminology that we're proposing to put in here now is much more in kilter with international best practice, with what practically everybody in the EU except the UK is doing in here. And we are really serious on this one, that it's a very important one, because as it stands now, it's just way too loose and vague. And there are implications for that. I mean, there are direct and worrying implications for freedom of speech. Because under the bill, the way it is drafted now, making a public statement, say, to the effect that Palestinians or Iraqis or people from Afghanistan who've been persecuted have a right to resist their persecution through armed struggle, could be construed as encouraging, directly or indirectly, the commission of a terrorist activity. And it could be prosecutable, which I think is completely disproportionate. It could be the case as well that advocates of, say, direct action against corporations, against government policies or intergovernmental organisations like the EU could also fall foul of public provocation offences, because, you know, the definition of a terrorist keeps changing all the time. Now, I know that the Minister in the discussion earlier in the month tried to tell us that public provocation wouldn't criminalise acts of civil disobedience, and she leaned that opinion on Section 6.5 of the Criminal Justice Terrorist Offences Act, where she said that this section says that the engagement in protest, advocacy, dissent or in strikes, lockouts or other industrial action is not of itself a sufficient basis for inferring that a person is carrying out an act with the intention specified in paragraph B of a terrorist activity. But you see, the problem there is that the section specifies only that protest acts of themselves are not sufficient to be construed as being carried out with the intention of, say, seriously intimidating a population, unduly compelling a government, or seriously disabling or destroying a fundamental political institution. But it doesn't, if you like, blanket or it doesn't bracket protest acts in and of themselves as a form of protected measure or as a free speech. So, if you like, such acts could be judged to be performed with one of the intentions above. There's nothing to say that they wouldn't be. And, they could then be prosecuted on the basis of a terrorist offence, even if, we're not saying incitement, but sort of some indirect encouragement. I mean, that's what it says. It's so vague, it's incredibly dangerous. I mean, one of the examples on this is one in the schedule is endangering traffic to constitute a terrorist offence rather than, say, a criminal offence. Such endangerment of traffic, for example, needs only to be committed with a view to unduly compelling a government or organisation to perform or abstain from performing an act. So what's to say a protester sitting in front of a car, say, for example, in Tallaght, wouldn't be doing an act which is being construed in this way? They're trying to get their government to change something that could be prosecutable as a terrorist act under the bill and the way in which it is drafted now. And it's all very well the minister saying, oh, we wouldn't do that, that had never happened. But such instances have happened before. And that, I'm sorry, I know the minister must obviously have a press engagement elsewhere, but these are actually pretty important issues as well. And the implication on freedom of speech is of huge concern to citizens, because our freedoms were hard fought for and now they're being given away without a batting of an eyelid. And such legislation is designed to deliver a chilling effect on freedom of expression and undoubtedly will have that impact if it's not challenged. And I think it's completely unacceptable. I mean, we know that there are protections under the framework decision in the Convention on the Prevention of Torture and so on with regard to freedom of expression. And no doubt the Minister will tell us, oh, that's there, that's protected. But, there's still been a number of prosecutions under the criminal incitement laws, despite the fact that those protections are there, if you like. You need to take a couple of examples. In Austria, a Danish cartoonist was arrested, had his material seized for putting up posters in Vienna, criticising the Russian President Vladimir Putin on the death of Russian journalists by putting the words up, shoot and Putin on the poster. In Azerbaijan, a person was convicted of inciting terrorism and sentenced to 8.5 years for writing an article opposing Azerbaijan's support of US policies relating to Iran. So these things do happen, and saying they don't is really not good enough. And I think we should be concerned. I think it's worth saying as well that countries like Canada, where such provisions were attempted to be brought in, there was an absolute outcry, and they were viewed with horror, really, by legal scholars and free speech advocates. So we have to ask, is this measure worth it in terms of what we're going to get out of it? Because international human rights law requires that any interference with a human right has to be necessary and proportionate. So interference with freedom of expression will be deemed to be necessary only if it fulfills a pressing social need. Where is the pressing social need for us to bring in this measure? It's absolutely not there. And, I think the points we're making here are very important. I think the measure of the Second Amendment, Amendment number 4, is particularly important. It's imminently doable, to use a favourite Labour Party expression at the moment. It's doable for us to pass this amendment, because the reality is many of the other European states don't include the offence of indirect provocation at all. Ireland isn't under any obligation whatsoever to do this. And apart from that, even if we were, we'd have to say there's been plenty of international obligations that we've signed up to that we haven't implemented in national law. And the reality is that many European statements do not use the word encourage because it's too vague, and they instead use the precise term of incite. Incite is also, we'd have to point out, the expression and the terminology that's used in the framework directive itself that we're asking to transpose into our law here today. And this is a really critical point. And I just want to briefly give a couple examples of other countries. Bulgaria, the definition is openly inciting the perpetration of a crime by preaching before many people, by distributing printed works and so on. It's not limited to terrorist offences, but it does refer to crimes in general. And they specifically exclude terminology like encourage. In Germany, they say only written materials that could serve as an instruction for the commission of a terrorist offence, and so on. In France, which is obviously, the known, I suppose, in some ways for its freedom of the press, but public messages inciting crimes are an offence. But this provision explicitly covers only direct provocation, and provocation is only an offence if the incitement is acted upon. In our piece, it isn't. You could be prosecuted for encouraging somebody to do something that they didn't end up doing. It's literally that vague, that what we're transcribing into our system now. I won't go on, but there are other examples. Italy, Hungary, similarly put in restrictions which leave it open to incitement and not the general terms of encouragement. But not only those countries that don't include it, even countries which do include it are much more definitive than Ireland is in this regard, because of the restrictions on human rights. And I think it's actually telling about a lot of what this government does, that the only country actually which is as vague and loose as ours and has that flabby definition of public provocation is the UK. And it seems to be basically transposed from the UK Terrorism Act of 2006. This was the act and the legislation, the only one in Europe which introduced an offence of the encouragement of terrorism, which includes the publication of statements that are likely to be understood as direct or indirect encouragement or other inducement to the commission, preparation or instigation of acts of terrorism. So this is where it's coming from, and it's completely out of kilter with the rest of Europe. That provision actually has been the subject of a lot of serious complaints internationally by human rights bodies, because it uses the word encourage rather than incite, but also because it lacks any provision for imminent threat or danger to be there. So this, I think, is a really poor piece of law. And ironically, the European Parliament had the same concerns, because in September 2008, it voted to amend the definition of public provocation in the framework decision, such that it read, public incitement to commit a terrorist offence means the distribution or otherwise making available of a message to the public, clearly and intentionally advocating the commission of one of the offences listed, where such conduct manifestly causes a danger that one or more such offences may be committed. And that's not what we're doing here. We're going way beyond that. Now, in the end, some elements of this amendment were actually dropped in the end, but the wording stands, if you like, it now stands as public provocation to commit a terrorist offence, and it again repeats the words incite and causes a danger that an offence may be committed. So I think it's important that we take those points on board. I think there's a lot of evidence internationally which deals with the issues of restrictions on human rights. There's a lot of warnings about the need not to enshrine in law loose, flabby, broad definitions. It's not good policy, and it leaves itself open. The International Commission on Jurists were asked by the Council of Europe to review the framework that we're now putting into our law, and they repeatedly warned that enshrining offences as vaguely worded as encouragement or glorification in legislation would run up against a host of human rights issues, and they suggested that the word incite should be used. And I think it's really important that we look at it. The Berlin Declaration itself said we should steer clear of this type of thing. So that's why we're moving this forward now. An offence of indirect encouragement of a terrorist activity with no explicit mention of the need for a direct and immediate connection between the speech and an act that follows is really dangerous, and I think it puts us out of kilter with everybody else. I think apart from that specific point, general free speech implications are quite serious, because undoubtedly it will succeed of having a chilling effect, a bit of self-censorship, if you like, and it is, in my opinion, counterproductive in alienating communities which perceive that the legislation is against them. Like, we're all talking about inclusion now and equality and so on, but this is given the wrong signal, in my opinion, and I think we have to be a lot more specific. Sadly, the reality is that we live in a much more dangerous world than we did in 2001, and the root cause of that was the illegal invasion of Iraq and the subsequent destabilisation of the Middle East. And unless we discuss the conditions that those people who are being, if you like, the conditions are leading them to be engaged in terrorist acts out of utter desperation for the devastation which has been meted on their country, then unless we tackle those things, you can have all of this legislation standing on its head, decades of battles of people for civil liberties, and the world will be still a much more unsafe place than it is now.